over to you, Joel. We know many employers will need to change employee roles as a result of the pandemic's impact. What are the risks in making these changes?
Well, the big risk here is constructive dismissal. So as many here will know, constructive dismissal legally is when an employer unilaterally makes a significant change to a fundamental term or condition of employment. The most common that we see is a big reduction in pay. That can often amount to constructive dismissal. Now, when an employee has been constructively dismissed, they can treat their employment as having been terminated by the employer and demand that the employer pay out their entitlements as though they were let go by the employer without cause. Now, during the pandemic, the most widely discussed potential constructive dismissal exposure for employers has been layoffs. This, before the pandemic, was not very well known amongst employers, and it's something that employers are starting to know a lot better now. There's a general legal principle that a temporary layoff is a constructive dismissal unless the employment contract includes a specific clause that allows the employer to lay the employee off. Now, that's the case even if the layoff is done in accordance with those applicable employment standards statutory layoff rules that Ioana spoke about a moment ago. Now, before the pandemic, again, a lot of employers didn't know, but now there's been so much discussion, it's on everyone's radar. There's been widespread speculation amongst employment lawyers as a result of this about even whether that general rule that a layoff is going to be a constructive dismissal unless there's the right to do so, whether that's going to change because of the pandemic. Some lawyers are speculating that the courts are going to fully change the law and say layoffs are no longer constructive dismissals. Some think that's just going to be a temporary change, so courts will say it's not a layoff when it's a COVID-19 specific, it's not a constructive dismissal when it's a COVID-19 specific layoff. And others think that the legislators in the provincial governments across the country are going to change employment standards legislation to make it very clear, again, that a layoff is not a constructive dismissal. The reality is, we don't know. There's been no guidance at this point about whether layoffs are still constructive dismissals from provincial governments, and many courts across the country have been closed except for very urgent matters, and so the courts haven't had a chance to provide their opinion on this yet either. And so everyone is really speculating at this point. In my view, it's unlikely we're going to see a legislated resolution from the provincial governments in employment standards legislation. So employers that laid employees off because of the pandemic and don't have those layoff clauses should expect to see a major increase in litigation in the coming months from employees claiming that they were constructively dismissed when they were laid off. Now, some may be thinking, we haven't seen this yet, and that's absolutely true. At this point, we haven't seen too many of these claims that layoffs are constructive dismissals because employees, for the most part, have preferred to keep a job while we're in the thick of the pandemic before considering litigation. But once businesses start to really get back to work in a somewhat more normal manner in the coming months, we're going to see more of these layoffs. Because don't forget, employees have 2 years to commence litigation in most jurisdictions across the country. Now, I also think we're going to see these litigation layoffs for a couple of other reasons as well. One is that some lawyers who act for employees have been very vocal in the media, in newspapers, and on TV shows, really encouraging employees who have been laid off, even temporarily, to go and sue their employers for constructive dismissal. And when lawyers are suggesting it, oftentimes some employees will take them up on that suggestion. And in addition to that, in Ontario specifically, just at the beginning of 2020, the amounts that plaintiffs can claim in Ontario's small claims court and in simplified procedure litigation in the Superior Court in Ontario were increased fairly significantly. And both of these are ways for people to bring expedited, less expensive lawsuits than usual. And so that's going to make it easier for Ontario's employees to pursue these types of claims against their employers. Now, layoffs are not the only type of constructive dismissal. I said before, reductions in compensation are the main one we see. There's also changes in hours and changes in roles that can also result in constructive dismissal. And a lot of employers have had to unilaterally reduce employee compensation and hours, and in many cases roles to fill in for others who are laid off, instead of laying off all of the employees during the pandemic. Now, generally, you can expect that if compensation decreases by more than about 10% or so, there is a significant risk that that change is going to amount to a constructive dismissal legally. And that's the case whether or not the hours were reduced to, so that the employee is only actually being paid for the hours they work. And it's also generally the case even when those compensation reductions are intended to be temporary, as most of them are these days with COVID-19. Now, again, employees who experience those temporary compensation reductions because of COVID-19 that were unilateral from the employer have in large measure held back, from suing employers for the same reasons that those who were laid off have as well. They'd rather keep the job right now while we're in the thick of the pandemic. But in the coming months, just as we expect to see those who were laid off start to bring more lawsuits against employers, we expect those who had pay reductions to start doing the same thing as well. So something for employers to look out for. Now, a lot of employers also ask us whether they can defend against constructive dismissal claims based on hours or compensation changes, based on clauses in employment contracts that broadly allow employers, give them the discretion to change compensation, change hours, etc. And what employers should understand there is that courts will not blindly enforce these types of clauses. If an employee has not had any reduction in pay or hours in the months, or in many cases, many years since the contract was signed, and then suddenly the employer imposes that, the courts generally aren't going to enforce those types of clauses to let employers make these significant cuts at this point while avoiding that constructive dismissal exposure.